Good morning. My name's Todd Smith. I'm a partner at Dana Whiting Law. I'm here with my senior managing partner,
gray-haired old war dog,
Matt Dana, the man that taught me everything I know. Didn't take
Come
long.
on, cut that out.
Didn't take long.
Cut that out. All right, Todd, today we want to talk about a revocable trust concept that I think is a huge problem out there that most people are unaware of. It'd be kind of like a mine. What's that called?
A minefield.
Minefield, there you go.
Legal issue minefield.
And so this video is very pertinent to married couples, estates between 2 and 10 million that have a revocable trust, correct?
There's a lot of demand for answers to this kind of question.
And there's a lot out there on Instagram I've seen, and there's probably a lot out there on the internet. What makes this thing difficult is it's a little bit difficult to explain, but I'm going to try to get it down to layman's terms where we can understand this. And what we need to focus on here, that this tax trap is that we have to understand what the terms cost basis means. And Todd, how would you explain this idea of a cost base and what that means to capital gains?
Yeah, so cost basis, the way I explain it, I generally can't explain it without just giving an example.
Okay.
I talk about buying an asset for $100,000. Everybody understands the concept of buying an asset.
That's the cost base.
You've bought it for $100,000, but say years later you sell it, okay? You sell it for $200,000. So you get proceeds from the sale of $200,000 that you're putting in your pocket. So I ask the question, are you going to pay tax on $200,000? And the answer is no. You're going to subtract out what you paid, which we're calling the cost basis. So your basis is the $100,000. So you're only going to pay a capital gain tax on the difference between that sales price and the cost basis.
Okay, now what happens, husband and wife, we own this asset together, and let's just for a minute talk about we're in a community property state, which Arizona is, and the husband dies, the same example, they bought this stock for $100,000, they haven't sold it yet, but the day husband died, it's worth $200,000. Now what happens to cost base?
So there's a beautiful thing happens, especially in community property states, and that's for tax purposes, the cost base gets adjusted to whatever the value was on the date of death.
We call that a stepped up base.
Call it a stepped up basis, and the part that is an important point that I think is missed by a lot of people is in a community property state, logically it would only be the deceased spouse's half that would get stepped up.
Yeah.
But in Arizona, which is a community property state, and in all community property states, we get the benefit of stepping up the base in the entire asset, both the decedent's half and the survivor's half.
Yeah.
So that $100,000, if it's worth $200,000 when husband dies, going forward, wife's basis in that asset is $200,000.
Yeah, and impress the heck out of you. That's Code Section 1014. Says when somebody dies, you get a stepped up base. The dead person gets a new base. In Arizona, we get a double step up. Not only the dead guy steps up, but the surviving spouse steps up.
So what kind of flexibility does that give to the surviving spouse with respect to that asset?
She can sell that stock the next day and pay zero capital gains. You and I met with clients yesterday that I think the estate was, in the, $50 to $60 million range. Husband just died, and we were, shedding a tear, and we wanted to be sensitive. But we were saying from a tax standpoint, everything they own, their business, their homes, their vacation, all got a new base. It could all be sold the next day. Good news. All right, so what's this tax trap? Well, the tax trap is most married couples that have a revocable trust, they have it where when the first spouse dies, it splits into a survivor half and a decedent half. And if you want to know if this is your trust, go pull it out. I'm going to go out on a limb. It's probably Article 4 or 5. It's going to say, upon the death of a trustor, this trust will be divided. And it'll say the marital half of the survivor goes to the survivor's trust. The marital half of the decedent goes to the decedent's trust. And we call it, in our words, an A and a B trust. A for the guy that's alive, B for the guy that's buried, split. Very common. I think most trusts out there have that type of a split in it. Now, on the stepped up basis concept, Dad died, that stock stepped up to $200,000. That was a community asset. Now that stock is split, half goes into the decedents, half goes to the survivor, both with a new base. Now, Mom, the survivor, lives 20 more years, and that stock that's $100,000 in the decedents and $100,000 in survivors, it's gone up to $500,000 in each trust. And now Mom dies. Are we going to get a step up in basis on Mom's survivor's trust?
Yes, and for the exact same reasons as when Dad died.
Okay, Mom owned it, 1014 steps in, step up in basis.
Right.
On the decedent's trust, are we going to get a step up in basis?
I'm going to go out on a limb and say if they did their trust before 5 years ago or so, probably not.
Yeah, and I'd go out on a further limb and I would say most of the trusts that we review, there's provisions in there that were done at a time when it made sense for other tax purposes. Right. For the estate tax purpose, it made perfect sense. But under new tax laws, it makes no sense because the way those trusts are drafted, that decedent's trust is not going to get a second step up in basis.
And I think that the simplest explanation is that that decedent's trust is not Mom.
Yeah.
Generally speaking, the survivor's trust, from a tax perspective, is Mom.
Yeah.
And so since the asset in the decedent's trust is not Mom's asset, then it has no relation.
Yeah, the decedent's trust didn't die. Dad died years ago and they got the step up. Now Mom died and she's outside of the decedent's trust, so no step up. So the message here is if you're in that category, $2 to $10 million, you did a revocable trust, you're a husband and wife, needs to come in and needs to be reviewed.
Right, and to your point, the estate tax laws were different when it was done, and it may have made sense when the attorney did it.
Yeah, we're not saying the attorney committed malpractice when he did it 10 years ago. Right. Now, my problem is, Todd, there's attorneys still doing it today, and they are committing malpractice. And I think there again, doing this online with self-serve type tools is very dangerous because you don't know what that provision is, what triggers that. But thanks for your time today. I learned a lot. I think you did good today.
Yeah, so did you.